Good morning, everyone. Welcome to SNO IP's monthly webinar, and thank you for taking time to join us today. My name is Natalie Nadoevi, and I'm excited to be here to discuss a topic of growing importance with you: trademark enforcement in Georgia, a key emerging hub for businesses operating at the crossroads of Europe and Asia. A little about myself. My name is Natalie Nadoevi, and I'm Georgian citizen. I work as an IP associate with SNO. My professional expertise includes trademark registration enforcement in Georgia, combating counterfeit through custom procedures, and delivering practical solutions for effective IP rights protection. Academically, my focus lies in international law, data protection, and the security of human rights. I specialize in intellectual property law with a particular emphasis on trademark registration and enforcement strategies, of course, not only in Georgia, but also across the broader region. If you have any questions during today's webinar, please feel free to submit them to my email that you can see right now on the screen. I will be happy to address them and follow up afterwards. To give you an idea what to expect from today's, here is an overview and agenda of our webinar. Okay. First, we will cover the legal frameworks governing trademark protection in Georgia. Next, I will walk you through the key enforcement practices and practical strategies that businesses can apply. And finally, we will discuss real-world challenges, and I offer actionable solutions to help you effectively safeguard your brand in the Georgian market. By the end of this webinar, you will have a clearer understanding of how to navigate trademark protection and ensure your intellectual property rights are well protected in the evolving legal landscape. Feel free to take notes during the session, and remember that this webinar will be recorded and shared for future reference. Well, let's have an overview about what is happening in Georgia. Georgia's strategic location at the crossroads of Europe and Asia, combined with its growing economic integration into global markets, makes the protection of intellectual property rights, and particularly trademarks, increasingly vital for businesses. Trademarks are much more than legal tools, and we are aware about of it. They are crucial assets that safeguard your brand identity. Of course, they build consumer trust and drive market success as well. In today's session, we will examine how the evolving legal landscape in Georgia supports trademark protection and how businesses can leverage this system to effectively protect their intellectual property. So whether you're already established in the region or looking to enter the Georgian market, understanding this dynamic will equip you to navigate the opportunities and challenges within the market. To begin, I'd like to start to talk about the key legal frameworks that govern trademark protection in Georgia. The primary legal foundation for trademarks is the Law on Trademarks of Georgia, which serves as the cornerstone of trademark protection. So while certain rights, such rights to a name or rights to the freedom of intellectual property, are addressed in the Civil Code of Georgia or even in the Constitution of Georgia, trademarks as commercial identifiers fall under this specialized legislation. I'd like to pay attention to the definition of the trademark under this law. So any symbol or combination of symbols entered in the trademark register, which is clearly and distinctly formed and has the ability to distinguish the goods and or services of one enterprise from the goods or services of another enterprise. However, not just any symbol can qualify as a trademark. To make the cut, trademarks must meet several key criteria, and let's break down these criteria. So first is distinctiveness. A trademark needs to be unique and distinctive. This one is the most critical factors when applying for registration. Well, the more unique the symbol, the stronger the trademark. Second is non-descriptive. A trademark cannot simply describe the goods or services it represents. For example, terms like red wine, best wine, or white wine would not qualify for wine-related trademarks. Of course, trademarks cannot mislead consumers about the products of origin or nature. For instance, imagine a Georgian-made perfume featuring the Eiffel Tower. That's of course problematic because it falsely implies a connection of friends. Of course, respect for public order and morality, because trademarks cannot include offensive symbols or politically sensitive emblems like fascist or communist ideologies and others. And in the end, trademarks cannot include protected destination of origin unless the applicant has a legal right to use that. For instance, using the name of Huanchgara or Bahmaro would require proper authorization. How do you actually register trademark in Georgia? It's very important to understand because here the Sakbadendi, the National Intellectual Property Center of Georgia, plays a key role. The process is not complicated, it's straightforward, but it's structured. So that's why here's a quick overview to guide you through this step. The process starts with submitting an application. It can happen either online or in person in Sakbadendi. Depending on the type of trademark, additional documents may be required, such as a power of attorney if you're using a representative, a copy of the first application if claiming priority from an earlier filing, and other relevant paperwork like certification for collective marks and others. Then we have formal examination, which happens within 1 month. During the step, Sakbadendi check that all the required paperwork is in order and that your application is complete. Then we have substantive examination, which takes about 6 months. And this is where things get more technical. The trademark is reviewed to ensure it meets all the criteria. So it can be legal and technical requirements. For instance, does it meet with the distinctiveness criteria? Is it non-descriptive? Are there conflicts with existing trademarks and so on? So in that stage, they will check legal and technical requirements together. Then, if the trademark passes substantive examination of the application, it's published. This marks the start of 3 months opposition period, where the public can raise any objections to the registration. If no objections are raised during this opposition period, or objections are raised but they are resolved, final fees are paid and the trademark is officially registered. At this stage, you will receive an official certificate confirming your rights. Why registration is important? So after the registration, it means that trademark grants you exclusive rights to use the mark. This means that you can prevent others from using a similar or identical mark for the same or similar goods and services. And of course, if you want, you can license or transfer your trademark rights to others, which can open to additional commercial opportunities for you. It's important to note that once registered, your trademark is valid for 10 years and you can renew it indefinitely in 10-year period. Of course, provided the renewal fees are paid on time. It's important to understand how Georgia's legal framework aligns with the international standards because you can protect your trademark not only within Georgia but across global markets. Georgia adheres to NIST classification, which organizes goods and services into 45 distinct classes, and this system provides clarity and consistency. For figurative marks such as logos and images, Georgia follows for Vienna classification. This systematic categorization of visual elements streamlines search and helps identify similar trademarks efficiently. Of course, Georgia is a member of Paris Convention, and Georgia ensures equal protection for both domestic and foreign applicants. Additionally, the 6 months priority period allows businesses to file the same trademark in Georgia while retaining the original filing data from another member country. Through Madrid Protocol, businesses can seek international trademark protection by filing a single application, which simplifies and streamlines the process for both Georgian companies expanding abroad and international businesses entering Georgia. And finally, Georgia complies with the TRIPS agreement, which sets global minimum standards for trademark protection and enforcement, aligning the country's IP laws with international best practices. So by adhering to these international agreements and systems, Georgia not only enhances the legal security of trademark, but also creates an accessible pathway for businesses to expand into global market with confidence. Well, having explored the legal foundation, let's move to the critical question: how the trademark rights enforced in Georgia? How does the law get implemented in practice? Once a trademark is registered, enforcement becomes vital to safeguard your intellectual property. preserve your brand's value, and of course, to prevent unauthorized use that could harm your reputation on the share market. Enforcement in Georgia spans administrative, civil, and criminal measures, ensuring a comprehensive system for protecting right holders. Also, an important element of trademark protection is preventing counterfeit or pirated goods from crossing borders, where custom authorities play a vital role. So that's why I would like to start with talking about the collaboration between Sakbatendi and customs, the revenue system, because it's very important to understand the administrative body's role in this safeguarding process. Custom authorities have very close collaboration between Sakbatendi, the National IP Center, and they work together. But how it works? Here is a brief overview of the procedure that you can take a look. First, trademark owners can register their mark within the Customs Department, enabling authorities to detect and suspend suspicious goods. Also, it's important to note that parallel imports are not prohibited in Georgia, so anyone can import the goods Georgia, even though if you're registered as a representative of this trademark or not. Then we need to take a note about the border enforcement, because customs may suspend the release of suspected infringing goods. And owners in that cases are not notified, and they must act within the designated time frame to prevent goods from being released. Then we need to take a look about the control measures, because for unregistered trademarks, release can be suspended for 3 working days while owners take actions, and for registered trademarks, suspension lasts 10 working days, or 3 days for perishable goods. Owners also can inspect goods, request expert examination, and document infringements, because it helps them to collect evidences and to prove their rights. And in the end, confirmed counterfeit goods may be destroyed within 10 working days upon mutual agreement. It's important to note that sometimes the financial responsibility lies to the right holder. That's why the problem can still be unresolved, and that in that case, the case proceeds to court. It's important to understand that to right to sue or to initiate legal actions in court is a fundamental right, and it cannot be taken away from an individual or entity. So in any case, if you cannot reach your ideas or your results in the customs, of course, you can initiate legal actions through the court. In this slide, we can also see the exemptions, because small quantities of good for personal use or unauthorized good exceeding agreed limits are exempt. Well, this was about the customs role in enforcement process. Now we can move to infringement enforcement, such as counterfeit goods, in the court proceedings. We need to understand that it's essential to explore 3-tiered approaches: administrative mechanism, criminal enforcement, and civil litigation. Each offer distinct tools for trademark owners to safeguard their rights effectively and to ensure a layered and comprehensive response to infringement. I'd like to start with administrative mechanism, as I mentioned, because custom is under the Department of the Revenue Service. And in that case, administrative measures are a faster and more cost-effective alternative to traditional litigation. So these mechanisms are proactive and enabling trademark owners to mitigate the spread of counterfeit goods without the delays often associated with judicial proceedings. However, their effectiveness is enhanced when integrated with criminal and civil enforcement. So let's take a look about the criminal enforcement, which are essential for addressing the broader societal harm caused by counterfeiting, such as threat to public safety or organized crime links. A complaint can be lodged with the investigative department of the Ministry of Finance, which specializes in handling intellectual property crimes. It's very important to understand that all criminal enforcement starts through the Ministry of Finance and specifically the investigative department. This step targets the root of the counterfeit supply chain, aiming to dismantle operations producing or distributing infringement goods. So criminal proceedings and criminal enforcement not only penalize offenders, but they also serve as a strong deterrent to potential infringers. Penalties may include fines, or in some cases, it can also include imprisonment or other sanctions, depending on the scale and quantity and intent of the infringement. And let's move to civil litigation, because for directive compensation and specific remedies, civil litigation provides a structured approach to resolving disputes. While administrative and criminal mechanisms address immediate concerns, civil litigation focuses on a long-term resolution and financial recovery for trademark owners. First, it's important to understand that fact establishment and evidence collection is the vital step, and sometimes is really common first step. This involves buying the suspected counterfeit goods, documenting the process with photos and reports, and verifying the infringement. Of course, you can do it by yourself, but in Georgia, we have the National Bureau of Enforcement, which can assist in the process because it ensures credibility and thoroughness. Trademark owners can file claim to request different outcomes. For instance, they can request destruction of counterfeit good or prohibition of sale, or of course, one-time monetary compensation may be claimed for the damages caused by the infringement. The seller of the counterfeit goods typically becomes the first respondent in civil cases. So when start initiate legal procedures, of course, we need to name someone, and the most cases, the seller are the first respondent. The burden of the proof then may then shift to the seller to demonstrate they obtained the goods lawfully. So sometimes they name another person like supplier or a person who gave them this good. Why Article 45? It's very important. Here you can see the Article 45 of the law on trademark, which is the legal foundation of this that you can request through the court enforcement. So this article provides a detailed legal framework. So here we can see and what can you request as a damaged party. Let's break it down. So trademark owners have the right to request the immediate cessation of actions that violate their exclusive rights. Of course, this includes any unauthorized use of the trademark in commerce. Then we can say that if it's not possible to separate the trademark from the goods may be destroyed. Destruction can also apply for labels, packaging, advertising materials, bearing the counterfeit trademarks, and equipment used for producing counterfeit goods. Of course, for unauthorized use, the right owner has financial damage as well. So for that, they can ask compensation for damages. Trademark owners can seek compensation for any damages suffered as a result of the infringement. In that case, court will assess various factors, such as the scale of infringement, harm caused of the trademark reputation, and the financial impact on the right holder. A one-time monetary compensation can be also awarded instead of other remedies, and it's important to understand that this amount should not be less than the infringer would have paid to lawfully use the trademark. So this one-time compensation is also very popular in Georgian enforcement mechanism. When determining damages, the court considers several factors because it's more individualized assessment. And in that case, the court considers the nature and scope of infringement, the intent of the infringer, the reputation of the trademark in Georgia, and other relevant factors such as quantity or the infringer's conduct. This provision is so important because it ensures that trademark owners have a legal toolset for protecting their rights, both through preventive measures like seizure and destruction, and through financial recovery for damages caused by the infringement. Well, as we conclude this part, I'd like to take a look about the pros and cons of the court enforcement, because one of the key advantages of the court enforcement is that the decision made by the judge is legally binding. So once the decision is final, the trademark owner can proceed with the enforcement of the judgment, such as the destruction of counterfeit goods or the collection of damages. Of course, a significant benefit of going through the court is that the judge had the authority to request additional evidence or proof. Why is that important? Because while appealing through the administrative body, you cannot ask any additional evidence to be collected by administrative authority, while in the court participates by themselves, so they will ask additional evidence or proof from both parties. Of course, comprehensive remedies is one of the common key advantages, and accountability as well, because in court proceedings, the responsibility for providing proof of the legitimacy of the good and their acquisition falls under of the defendant. About cons, I would say that court proceedings can be expensive, particularly when hiring legal experts, and it's time-consuming that legal proceeding in court can be lengthy. So it may take several months or even years for a case to reach a final decision, particularly if we consider appeals or delays in legal process and so on. And as I mentioned, like Apple possibility is good from one side, but also it causes like delays and maybe the court decision can be prolonged. And enforcement only after final decision, which means that only after final decision, after the time passed for appeals, the enforcement can be done. So while court proceedings offer significant advantages, I'd like to conclude that, including the ability to request additional evidence and enforce comprehensive remedies, they come with notable drawbacks as well, such as high costs, time delays, and the potential for appeal. Well, in Georgia, there is a limited court practice related to intellectual property matters, especially in the field of trademark enforcement. However, there is several interesting cases, and one is this case that I provided for you. And this case really stands out because it involves a well-known alcohol brand, Stolichnaya. This case provides valuable insights into how the Georgian court address trademark disputes, even though such cases are relatively rare. The Stolichnaya case involved a trademark dispute over the use of the brand name by another entity, and the case attracted attention not only due to the prominence of the brand, but also because of the legal principles at stake, including the protection of well-known trademark and the enforcement of exclusive rights in Georgia. In this case, the court carefully considered the evidence presented by both parties, and they also rely on the brand reputation and the potential consumer confusion caused by the unauthorized use of the trademark. Ultimately, the court ruled in favor of the trademark owner, and they emphasized the importance of protecting intellectual property rights to maintain brand integrity and to avoid any misleading information and any misleading confusion for consumers. So the court ruled that it should be prohibited from using the Stolichnaya trademark or any similar signs, including labels, marks, stoli, or any other similar that can use confusion. The plaintiff also saw the destruction of 90,000 bottles of alcohol, so it was a very interesting case from this regard as well. This case highlighted how court can request multiple enforcement measures in trademark disputes, such as the destruction of counterfeit goods and prohibition of further use of the infringing marks. Importantly, it demonstrated that damages is not a one-size-fits-all process, so court makes an individual assessment for each case and taking into account factors like nature of infringement, the impact of trademark owner, reputation, and so on. So in this case, the Supreme Court of Georgia upheld the decision of the Court of Appeal last year, and they protected the trademark owner's right in this case. Well, before going through closing remarks, I would like to check my email if there is any question to address them. Thanks for the question. Here is several one, but I'm running out of time, so I will address only one or two. So Are administrative measures enough to stop counterfeiting, or should we go directly to court? Thanks for the question. So, as I mentioned, administrative measures such as working with customs or working with revenue services within the Georgia, or to work with customs to have an effective remedies in the border. Administrative measures can be often faster and more cost-effective for immediate relief. However, if you're searching for different outcomes, if you're searching for large-scale infringements or disputes requiring compensation or court proceedings, in that case, you really need to start court actions, because in that case, court proceedings are necessary and more effective, because combination of both approaches will have the best result. And another question is, what should I do if someone uses a trademark similar to mine but claims it's different enough to avoid infringement? So it's a very interesting question, and thanks for that. So the case I provided included the similar topic, because in that case, it was mentioned that they prohibited not use only Stalichaya, but similar names and similar trademarks as well. So it's essential to assess whether the similar trademark causes confusion or takes advantages of trademark reputation. So the court, when you start and when you initiate a legal challenge through civil litigation, and when you provide evidence of similarity, then the court will evaluate factors like visual, phonetic, and conceptual similarities, as well as the target audience or the market reputation and market overlap. So if infringement is confirmed, remedies such as cessation of use or monetary compensation can be thought. So I will conclude my webinar right now. Thank you for joining today's webinar on trademark enforcement in Georgia. I hope that you found the information useful and you are now more equipped to understand the various legal avenues available to protect your trademark, whether through administrative, criminal, or civil means. We've seen that enforcing trademark rights can be challenging, especially when dealing with counterfeit goods, because delays in court proceedings are very common in Georgia, and of course it can be a concern. Also, it's not cheap and it's costly. Another challenge is that you need to see counterfeit constantly, because you need this burden of proof to prove that there is some kind of infringing goods or counterfeit goods. But by staying proactive, whether through market checks or regular control purchases, you can stay ahead of emerging counterfeit trends. Also, speaking about protection, my suggestion would be that one of the most important things you can do as a trademark holder is to register a trademark with both SACPAT and the Revenue Service. So this will make enforcement much easier if you had the problem and if you ever need to take action. Along with registration, always keep an eye on the market and gather evidence to back up your claims when you detect counterfeit. You can do it by yourself as well, but for more accountability, you can use the National Bureau of Enforcement of Georgia. And don't forget that in that cases, you are not alone, because SNO IP team is here and we're ready to assist with consultation, guidance, and support in any trademark related matter. Thank you once again for joining us today. This was our last webinar for this month. Our team wish you Merry Christmas and Happy New Year. If you have any further questions, we are happy to provide answers and help you to protect your brand. Thanks.